Court of Appeals entered for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Evander, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good morning. Welcome to a session of oral arguments at the 5th District Court of Appeal. I've already been introduced. Let me go ahead and introduce the other panel members. Seated to my right and your left is Judge Richard Orfinger, and to my left and your right is Judge Rand Wallace. We only have one case scheduled for oral argument today. Each side will have 20 minutes. The appellant is entitled to divide that time between an initial argument and the rebuttal argument. So when you first come up here, if you let me know how much time you wish to save for rebuttal, I'll try to help you in that regard. If you have any electronic devices, make sure they're in the off or silent mode so that the oral arguments are not disturbed. So we'll go ahead and start with our one case today, the UP FIELDGATE versus Dick's Sporting Goods.
Good morning.
Morning.
May it please the court. I'm Linda Spalding White, and I have Nicolette Vilmos of Nelson Mullins Broad & Cassell, and we represent the appellant UP FIELDGATE, which I'm going to refer to as the landlord. And we also have a representative of UP FIELDGATE here with us this morning, Mr. Matt West.
Morning.
I would like to reserve 7 minutes for rebuttal.
Okay, you may continue.
We're here today because the trial court entered a final order of dismissal with prejudice, and he basically determined the rights and obligations of the parties right out of the gate. And the trial court did more than it was to do on a motion to dismiss, on a declaration of rights. He didn't confine himself to the four corners of the complaint. He improperly accepted Dick's interpretation of the lease. He ruled on the merits of the claim because he says specifically in the order, for the reasons and the additional reasons set forth by DSG in connection with the motion, landlord is not entitled to the relief it seeks. That is completely a merits determination on a motion to dismiss. The court also specifically found, which is a merits determination in paragraph 8. Moreover, section 1.7 is not unconscionable, nor does it set forth an impermissible penalty. That is a factual and a merits determination. And then the trial court further denied the landlord leave to amend when it specifically requested to do so. And we have to remember how this order was entered. There was a hearing, argument was presented.
Counsel, it appears that your complaint primarily focuses on the lack of what you describe as the equal bargaining power of the parties with regard to coming to negotiating the lease. Is that correct?
That is part of it. That would go to the procedural unconscionability.
Okay, and you discussed in the complaint or pled in the complaint on behalf of your client that your client came with, or that your client lacked equal bargaining power.
Correct.
Is that correct? Okay. Did you ever talk about and describe the bargaining power of the two parties other than making it seem like it was entirely one-sided?
We allege that they're the party that contacted Dick's to lease the space. We allege that they're the ones that drafted the lease. They're the party that specifically demanded that the lease have not just the ongoing co-tenancy requirement, but also the initial co-tenancy requirement with very specifics. There was a non-compete. There was also other violations if we didn't meet certain requirements where they could pay substitute rent.
Well, you made it sound like it was so one-sided that it was almost, I mean, it was, the way you pled it was entirely one-sided, correct?
Yes, Your Honor.
Okay, so the trial court, in asking what happened, what was the deal between the parties, I know you're saying that was going outside the four corners of the complaint, but made it sound like your client didn't even have the ability to say, no, we won't lease the property to Dick's Sporting Goods. But you didn't even plead that. You pled absolutely no power, it sounded like, of your client coming to this contract.
Well,
So why wasn't the trial court justified in saying, this sounds like it was totally one-sided, it sounds totally unreasonable? What happened? What did your client bring to the table as far as negotiating power?
that is something, Your Honor, that could be done at a summary judgment stage.
Understand.
It should.
But I don't think it was an unreasonable question from the trial judge at that point in the motion to dismiss, seeing an entirely one-sided complaint. Would you agree?
He could ask the question, Your Honor, but then he should have allowed us leave to amend to further allege facts to support the procedural unconscionability aspect of it.
And what facts would you have pled at that point?
Well, quite honestly, our counsel at the time didn't know because we didn't have access to some of the files. We are starting to learn some of the facts relating to the negotiations and how they went down, and would be able to allege more facts. I mean, the court also made a comment that this was probably a legal malpractice action because no lawyer in their right mind would have allowed their client to sign a lease such as this.
And you're
But-
specifically referring to contract to paragraph 1.7D, is that correct?
That is what this case, the issue in this case is. Now, the motion to dismiss and the court's questions went outside the scope of just the section 1.7 because it's very broadly worded order, because it says they accept Dick's interpretation of the lease, not just section 1.7.
Well, specifically 1.7D, where your client agrees that your client will not control or in the future will potentially have no control over the actual leasing of any portion of the mall, correct?
Correct.
Okay, so that's the focus, is that right?
Of 1.7D?
Yes.
Yes.
Counsel, excuse me, let me ask you about your equitable claims, your quantum merit and unjust enrichment. Would you agree that if the trial court finds that the contract is not unconscionable and does not rescind it, that you can't maintain those claims?
I would agree, Your Honor, that unless we can allege a specific claim that doesn't go to an express term of the lease, if we cannot do that, then
Yeah, but I'm trying to get it. At the end of the day, if the contract lives, you don't have an equitable claim, is that correct?
correct, Your
On
Honor.
the other hand, if the contract dies, then arguably you might have an equitable claim.
Yes, Your Honor. And yes, that is correct. And in addition, we're not really seeking to invalidate the entire contract. We are contesting the validity of Section 1.7, the validity and enforceability of that section. We're not trying
Let's
to,
talk about the allegation of unconscionability. I mean, basically, you make a very general statement that it's procedurally and substantively unconscionable because the parties didn't have equal bargaining power. And I guess I always think of an unconscionable contract. If I put a gun to your head and say, sign this lease or I'm going to shoot you, that seems pretty unconscionable. On the other hand, you know, a lot of things short of that don't quite rise to that level. But what facts did you plead that would provide some basis for a demonstration of unconscionable? I mean, I certainly agree. I mean, it seems to make business sense that Dick's wants a lot of traffic in the area, and apparently the mall's next door, or this is an out parcel or something.
No, Your Honor, it's a completely separate property.
So it's apparently next door or in the vicinity. So
Yes.
obviously they want something there that's going to attract a lot of people. I get that. That doesn't strike me as being unconscionable. What is it that's so what facts did you plead that would demonstrate that it was unconscionable? Or is your position here that you didn't plead enough facts and we simply should have had an opportunity to amend to plead greater facts?
I think it's both, Your Honor. And there's the two aspects of unconscionability. There's the procedural, which is what you're focusing on. And then there's the substantive, which goes to the reasonableness of the contract term.
Is there anything that you could plead that would say, my client didn't have the opportunity to say no, they couldn't help themselves? I mean, at the end of the day, Dix could ask for the moon, and you all had the opportunity to say no.
I believe there are some additional facts that I've recently learned of, Your Honor, that we've all recently learned of, that we do believe we could allege. But let's remember that the procedural unconscionability aspect, you look at the respective bargaining powers, who drafted the contract, the manner in which the contract was entered into, and that's where we believe that we have additional facts that are not alleged that we would be able to allege.
So again, let me just kind of circle back to where I was. Are you taking the position that you're not really contesting that the complaint was insufficient, but you should have an opportunity to amend, or do you think that you can really ride this horse to victory?
We would like the opportunity to amend, Your Honor, because we do believe we can set forth additional facts. And the substantive unconscionability, which is sort of similar to the argument that it constitutes an impermissible penalty, does go to the reasonableness of what they're receiving. And in here, we allege facts that they only paid through, I believe it was in 2017, about $117,000. The full minimum rent through that date would have been $276 plus or minus $1,000.
But doesn't the freedom of contract suggest that you also have a freedom to make a bad deal?
It does, but it doesn't mean that the court, and I wanted to point out one of the...
Is it our job to save your client from what they would contend is a bad deal?
Sometimes, yes, there is a case, which I will get, Your Honor, where the court, even if it's clear and ambiguous and they negotiate it, if there is an unreasonable relationship between the amount forfeited here, in our case, the landlord, which is 58% of the rent, that the court can determine that it is a penalty and declare it invalid and not enforce it. Yes, the court does have the power to do that, but the court certainly didn't have the power to do it on a motion to dismiss. The court didn't have the right to interpret the contract at the motion to dismiss stage. That can be done at the motion for summary judgment stage or at trial. None of the cases that really any of the parties rely on determined either of these issues, whether it's unconscionability or impermissible penalty at the motion to dismiss stage.
Did you attach a copy of the contract to the complaint?
Yes, we did, Your Honor.
Okay, so wasn't it proper for the judge to consider that attachment with regard to the motion to dismiss?
He could consider it, but he couldn't interpret it. And I did file, we had a case that addressed it, but I also filed as supplemental authority the Geeter and the Asia Telecom. And they say the trial court may not engage in contract interpretation at the motion to dismiss stage, as these are more appropriate for summary judgment. And that is the holding irrespective of if the contract is clear and unambiguous.
Did any party take the position that the calculation of the arrearage of the rent was inaccurate with regard to how the contract should have played out?
That is not pled. I believe it can be pled based on what we have learned about the negotiations and how the landlord exercised their right. I mean, there's even an issue here.
The
which,
appellee make the argument that it was an inaccurate calculation of the arrearages that were due?
in the complaint?
Based upon the contract, in the answer.
In the complaint?
Sorry, yes, in the complaint, yes.
No, we did not do that.
Let me ask you this. In your brief, am I correct that you're suggesting that there's also an argument that you could have pled, but you didn't, that the idea that they could have the substituted rent could go on for the entire term of the lease was an incorrect reading of the contract?
What we alleged, Your Honor, is that under the ongoing tenancy requirement, our client could be subject to that minimum rent for not only the initial term, but the whole 20 years up through 2045, where they only have to pay substitute rent. There is an issue which was alleged, and we wanted the opportunity to amend as well, is they are now contesting that they don't have to pay CAM and real estate taxes because of their construction of other sections of the lease, which we believe are ambiguous or actually do not entitle them to withhold.
All right, so that item was not alleged in your complaint, and you would want the opportunity to amend to allege that?
Yes, and the other thing that we want the opportunity to allege, as because it has also, after further review and obtaining information on the matter, is there is an issue here whether they even had the right to exercise their and claim that there was a violation of the co-tenancy requirement, because 1.7b requires that after the rent commencement date and the satisfaction of the initial co-tenancy requirement, only if those two conditions are met are they able to say, well, we want to pay substitute rent. And we would like the opportunity to allege, because we don't believe that the initial tenancy requirement was met.
And that was not alleged or an issue in the initial complaint?
No.
Okay, you're down to 4 minutes. I don't know if you want to save the
Okay.
rest.
We would respectfully request that we believe the trial court went well beyond what he should have done on a motion to dismiss in determining the merits, and we believe that it should be reversed and giving us leave to amend to either make additional facts and also allege additional claims that all should be in one action.
All right, thank you.
Thank you.
All right, you have a little over 3.5 minutes left for rebuttal. I'm sorry? You have a little over 3.5 minutes left for rebuttal.
Good morning. May it please the court, my name is Greg Call. I'm here on behalf of Dick's Sporting Goods. I'm from the firm of Kroll and Mooring, and appreciate the opportunity to argue this case in Florida. Let me first start out by saying that the world that the landlord wants to create is a world in which literally any commercial entity, based on general allegations, could attack the validity or the words that the parties have agreed to in the contract. You can plead conclusory allegations. You can argue that the contract itself should be ignored, and you can argue that you shouldn't be able to interpret the contract even if you don't ignore the contract.
Counsel, since we're at this stage of a motion to dismiss, can you explain to me how the court's question to the parties about how this deal went down, which I don't believe you're taking the position was clearly set out in the complaint, how is that not going outside the four corners of the complaint and being impermissible at the stage of a motion to dismiss?
Your Honor, in our view, that question would go to the issue of the ability to amend potentially to fix the problems with the complaint. And in that context, I think there are cases that we cite in our brief that allow such questions to go forward. But at any rate, our viewpoint is that the only things that you need to consider here to see that the motion to dismiss was properly granted were the words of the contract themselves.
Counsel, let me ask you this. I don't have so much of a problem with the granting of the motion to dismiss as I do with the failure to allow them to amend. I mean, I tend to agree that they make a lot of very general allegations. It's unconscionable and we don't have equal bargaining power. But they don't plead any facts that really support that. Why shouldn't they have an opportunity to amend? I mean, I think my view of the contract is they got a pretty steep uphill climb here. But why shouldn't we give them the opportunity to try to climb that mountain at the motion to dismiss stage?
Your Honor, what I want to do in answering your question is I want to divide the world into two sets of claims. One set of claims is the claims that they alleged in the actual complaint, which to me primarily involve unconscionability and penalty. The other set of claims, and then there's some that I just think fall away, and it's pretty clear based on the answers to the questions this morning probably do, are the contract interpretation claims that they're now seeking to bring up. But I want to focus first on the claims of unconscionability and penalty. And the reason I think the court was correct in not allowing amendment is that the words of the contract simply, and the circumstances that the contract sets forth, simply make it clear that it would be futile to allow them to amend with respect to
What
those
circumstances do we know of? I mean, going back to Judge Orfinger's initial example, I mean, what if their amended pleading was, he held a gun to my head and said, sign this lease? I mean, how do we know? So I obviously don't expect anything that egregious, but you just said that the circumstances we know are not sufficient. Well, the circumstances aren't alleged. So how do we know what they would amend?
Your Honor, again, I would focus on the words of what the contract says.
Yeah, but the procedural unconscionability goes to how the contract was entered into. And I agree with you that it was conclusory. What's in there now is insufficient to show procedural unconscionability. But without an opportunity to amend, how do we know what they could allege, and how do you know what the circumstances are based on that complaint alone?
Your Honor, let me just explain how we look at the contract and how we answer that question, and I appreciate the question. To start off with, when you read this contract, it's clear that the parties engaged in discussions and negotiations specific to this arrangement and this contract. If you look at Section 1.1 of this lease, in Section 1.1, it makes very clear reference to the fact that you have the landlord that owns the parcel that Dick's is going to lease, and then you have an affiliate of the landlord that has control over the mall. That's very specific to this lease. The details are very specific to this lease. Moreover, the parties negotiated individual economic terms applicable to this lease. They negotiated a rent. They negotiated an amount, and it's all filled in the contract, an amount with respect to common area, with respect to taxes. Also, 1.7 demonstrates that the parties specifically negotiated with respect to a co-tenancy, which again makes perfect sense, right? Dick's will pay more, is willing to pay more for a space in an area where there's lots of other people coming to go shopping. Perfect sense. 1.7 specifically talks about the co-tenancy regarding the mall, and then takes the very risk that they say is the basis for this being unconscionable, and that is that they're no longer, that the landlord nor its affiliates will no longer have any control over the mall, and it assigns that risk to them. That was specifically negotiated. What the lease also reveals on its face is that the landlord is sophisticated. They know what they're doing. They're involved in owning a property with 50,000 square feet that they lease to Dick's. Their affiliate it controls, I think via ground lease, the mall. The same individual who signed on behalf of the landlord signed on behalf of the mall on the signature page of the contract. The contract on its face shows that there was a lawyer involved on behalf of the landlord. That's both on the notice page and on the witness page.
Counsel, let's circle back to where I started. I frankly think on the merits you got a pretty good argument. But I don't know what other circumstances they might be able to plead, if any. They suggest that they've got other stuff that they can plead. If they can plead other facts, my only argument is not with the fact that the trial court granted the motion to dismiss. I think I would have done the same thing. My concern is the failure to allow them to amend. And I'm just trying to understand why they shouldn't have that opportunity. I mean, we allow liberal amendments and they haven't abused the privilege. That's really my only concern here. I really don't have any real heartburn over the fact that the judge dismissed the complaint. It's the failure to allow them to fight on.
Yeah, again, Your Honor, I think it goes to the issue of futility. With respect, again, I'm focused on what was in the complaint. The argument that somehow there was, it's so unfair to have us be responsible for the occupancy of the mall. My point is that no, it's not unfair to do that. There's no way they can overcome what's on the complaint. They can't overcome the fact that it was a negotiated element specific as to this location. They can't overcome the fact that they're a sophisticated entity.
But aren't those all defenses? I mean, those are great defenses. And, I mean, any landlord would like to have a credit-worthy national tenant like Dick's or Walmart or Academy Sports. I mean, everybody wants that. I get it. I mean, I'm sure that they were very happy to have a credit-worthy tenant.
Well,
again, my only concern is why can't they amend? I mean, they may not be able to put anything else in there that changes my mind because they didn't sell me on round one. Whether they could sell me on round two, I don't know.
Your Honor, again, it's that it's futile. It's all those factors I said. It's the mere fact, which was alluded to in the oral argument in some of the questions, is that, look, this landlord had plenty of choices. It's not like with respect to a situation where you have a space potentially to rent. There's certainly more than one retailer out there in the world as to who you can rent.
Listen, I agree. I think that's a wonderful defense. They had the ability to say no, and I strongly suspect at the end of the day that whoever was representing Dick's did not have a gun to their head. And, you know, they were anxious to have a credit-worthy national tenant, which was good for the mall, it was good for that tenancy, everything. I get it. I mean, I said, I think they got a very steep uphill climb here from my reading of the contract, but I'm only concerned about the liberality with which we allow amendments.
And, Your Honor, I certainly, again, I understand the point. Again, you know, our point is simply that given all the factors and the information we already have, and what the contract itself says, that it would be futile to allow them that attempt with respect to the claims that were pled.
All right, well, how about the second category? You said you're going to divide it into two categories, the items that they didn't plea, and they suggested they'd like the opportunity.
Yeah. Your Honor, as to that category, as I read the court's order and his initial order, minute order, where he says the amended complaint should be dismissed with prejudice. He's focused on the allegations of that complaint. That complaint can go away. If they want to bring up a new suit, and their argument in these new allegations isn't about throwing the contract away. It's about now trying to enforce or interpret the contract in a way that's different than the parties have interpreted the contract since the get-go. I think I said this at the hearing.
If that happened, see, you're suggesting, well, they could bring a new complaint.
They could bring a new complaint.
And, in Florida, the doctrine of res judicata can apply not just to what was alleged, but what could have been alleged. And, it certainly wouldn't surprise me if we allow that to happen, that the next thing that would happen at the trial level is your client filing as an affirmative defense res judicata, that they could have raised this in the case that got dismissed with prejudice, and they failed to do so.
And I understand that, Your Honor, and I appreciate that. I will just say the fact that they're raising these arguments is making that argument for us better as we continue forth here. There's another way to do it, which would be for this court, for example, to make its own distinction with respect to leave to amend, and make it clear that as to the claims that were pled and were actually part of the first amended complaint, that those are done. But they had raised these additional claims, and they can go back and raise those additional claims. I could understand that being the outcome. Our view of those additional claims, Your Honor, is that if you want to go to those additional claims likewise have no merit. Their first claim is this notion that somehow the language of the lease that says you pay substitute rent in lieu of capital R rent potentially does not include additional rent. Well, the lease itself in 4.1c very clearly defines rent as including both minimum rent and additional rent. So if substitute rent is replacing, quote, rent, it's replacing both of those items. I mean, we don't see there being an issue.
What is the additional rent is the CAM and the taxes?
The CAM and the taxes, yes. Yeah, and it's 4.1c, which says minimum rent and additional rent are collectively referred to herein as, quote, capital R rent. And what the lease then says is it says that in lieu of rent, we can pay substitute rent. Our view is, again, that's clear as day. It's right there in the words of the contract. They have no basis to go anywhere. Regarding their argument, their other so-called or claim, which somehow goes back to the initial co-tenancy provisions, and an argument that the initial co-tenancy provisions have a life. Well, the language of the lease only provides that there's a time period regarding those initial co-tenancy provisions with respect to the right to terminate, and that's in 1.6c1, where it's very specific that if you don't exercise the right to terminate within a 2-year period of time, you've waived the right to terminate. It says you've waived the right to terminate. Well, what 1.6b says is that if, from an initial standpoint, there's not a satisfaction of the initial co-tenancy, that the tenant shall be entitled to pay substitute rent in lieu of rent in arrears no later than the 30th day of the following month until the end of the month in which the initial co-tenancy requirement is satisfied. There is no limitation of time with respect to that initial co-tenancy right. Look, we're very comfortable.
So, counsel, are you saying then that any additional claim or amended claim with regard to paragraph 1.6 or 1.7, which I believe counsel was referencing earlier, would that survive a res judicata challenge in the lower court?
Your Honor, I don't know the answer to that. I don't know the answer to that. I think, to me, making the distinction between enforcing the contract versus trying to get rid of the contract might provide a basis for them to argue. But again, to me, the more
would you raise a res judicata challenge for 1.6 or 1.7?
Your Honor, I don't have authority to say I wouldn't do that, and I don't.
That's a smart answer, right?
Yeah, I can't say that I wouldn't do that. I understand the problem. I totally understand it. And I think they're exacerbating the problem as we go on, and they continue to raise this as part of this, action or this proceeding. That's been my reaction since the beginning with respect to that they're creating more of a problem for themselves. I understand the distinction, though, between the arguments the claims they want to make, which are interpretation of the contract, versus the claims they did make, which are basically throw out at least portions of the contract. I get the difference between those two things. And as I understood what the judge was ordering based on his initial order, is he was focused on the claims that they had actually already made. And that's how I understood it. That was my take on what had occurred. I don't know if there's any further questions. Obviously, we feel confident that the claims as pled simply don't survive, and the court was properly ruled with respect to the dismissal of those claims.
All right, thank you.
Thank you.
Excuse me, one second. I first just wanted to address the case that I said, and this was after a trial, and it's the Goldblatt decision out of the 3rd DCA. The mere fact that the parties stipulated to an otherwise unenforceable liquidated damages clause does not automatically render it enforceable. The clause can still be determined to be invalid. So even if we stipulated, even if we agreed.
Judge make the determination on a motion to dismiss by looking at the contract, whether it's a liquidated damage clause or whether it is what they've labeled as a two-tier rent system. If these conditions exist, this is the rent. If these conditions don't exist, this is the alternative rent. Can the judge look at the contract on a motion to dismiss and say, by its plain meaning and taking into account the entire contract, this is not a liquidated damage clause?
No. All of the cases cited by both sides said it might be able to be determined on a motion for summary judgment, but not at the motion to dismiss
But are those
stage.
cases where you're determining whether it's a valid liquidated damage clause or a penalty? I mean, isn't that what those cases go to? Determination of whether something is liquidated damages or whether it's a penalty, and one of the factors in determining that is whether you could have otherwise determined the damages?
What the cases say is whether it is a liquidated damages clause and then whether it can be enforced, both should be determined on.
But those cases are saying it's a factual determination as to whether it's a liquidated damage provision or whether it's a penalty.
Yes.
Here, there's an argument that can be made that is this a liquidated damage provision or is this simply a two-tier rent system?
Well, the Grand Prospect case and the Boca Town Center case that we cited says that it is not whether it's a liquidated damage, it's whether a conditional provision of a contract was not met, and based on the failure to meet that conditional provision.
Well, that's a different issue.
Right.
I understand that. Okay.
And on the motion to dismiss, we have to not get beyond the fact of the overbreadth of the order by accepting Dick's interpretation of the lease. And the order was based on not only what was in the order, but every ground asserted in the motion to dismiss and argued by the court. It's specifically in the order. It's very overbroad. And Dick's counsel is the one that drafted that order. And if you look at it, it looks like more of an order that you would see on a summary judgment. They drafted the order, and the court adopted it verbatim, without even giving our client the opportunity to object.
For you to prevail on your unconscionability argument, you have to show it's both procedural and substantively unconscionable.
Yes, Your Honor.
Now, the issue of substantive unconscionability, as I understand it, the contract has to be so outrageous, as I see it says, it has to be outrageously unfair and shock the judicial conscience.
Yes.
Now, my question to you is, number one, is that a question of fact or is that a question of law? And do you have any idea how hardened our judicial consciences are after all these years on that? I mean,
It is more,
I am
it's a
interested.
combined question. And what the cases say is you have to look at the totality of the circumstances surrounding the transaction. So it's,
That's for procedural unconscionability, though. It seems to be substantive unconscionability. Don't we just look at the words and say, well, okay, you know, if you've got this co-tenancy requirement and you've met it, they pay this much, and if you don't, they pay that much. I mean, what interpretation is needed other than for the court to say, well, that either shocks my conscience or it doesn't?
well, one of the cases that we cited, which was a real estate transaction, and in that case, it's the Boca, I think it's the Boca. The seller got to retain 55% of the purchase price if the buyer didn't go through. And they said, and they went through many different cases about what percentages or what amounts might shock the judicial conscience and might not. But in that case, 55% shocked the judicial conscience. Here, they're paying 58% less than the minimum rent. So under the cases that it construed, it could suffice to shock the judicial conference.
But my question, and I see you're out of time, and I appreciate the Chief Judge indulging me for a minute. Is that a question of law or is it a question of fact? If it's a question of law, why aren't we in just the same position to decide it as the trial judge was?
The cases seem to discuss that it's a mixed question, and in all of the cases where it's decided, there was expert testimony, there was other testimony. It was not based just on what was alleged and what was in the contract. They looked at the evidence, and there was testimony presented, even expert testimony presented in these cases.
All right, well, your time is up, and I want to thank both of you for your argument, and the court will be in recess.
Thank you all.
Thank you.